much, Mark, and it's great to be here. See such a terrific turnout, and on the ever fascinating subject of antitrust and how it relates to IP and international trade. We realize we're the last thing between you and a nice reception and a beautiful day outdoors, so we will act accordingly and get right to the main point. I want to start by describing in somewhat more concrete and vivid terms this phenomenon that's been referred to as by a number of speakers today, and particularly on the last panel, about the global growth of antitrust law. When I graduated from law school in 1976, there was exactly one prior merger review notification system in the United States, and that was the Hart-Scott-Rodino Act, and that was it. Now we've got probably around 90 merger review systems and almost 140 distinct jurisdictions and agencies that are actively enforcing antitrust law. And I'd like to point out that there are really three different trends within this amazing proliferation of antitrust that's occurred over the last 30-odd years. Number one, in the wake of the Soviet collapse in 1991 and the years of the Washington Consensus and the years of expansion of the European Union and the spread of democratic and market organizations and ways of thinking, scores of jurisdictions enacted antitrust laws for the first time, where they strengthened antitrust laws that had not previously been particularly well enforced. As soon as those agencies came into being, one of the things they started to do is form a network. And as a result, we've actually got the OECD publication of a list of bilateral memoranda of understanding and other kinds of enforcement cooperation agreements among the various agencies of the world. And I think they number probably around 200 at this point. But of course, if you can do 140 factorial in your head, you realize that there's a possibility of several thousand alternative combinations. So we've formed a number of multilateral cooperation agencies. One, the OECD Competition Committee, another, the International Competition Network. There's a similar unit within the UNCTAD structure of the UN that talks about agency cooperation. And finally, after we've formed a great big happy community of all these brand new antitrust enforcers, we have done something that I like to refer to as the weaponization of antitrust. The United States started out as really the only jurisdiction with very serious penalties and actively enforced enforcement provisions in antitrust, by which I mean criminal remedies, both for individuals and corporations in the enforcement of antitrust law, a private attorneys general provision which allows anybody injured by an antitrust violation to sue and recover treble damages plus reasonable attorney's fees expended in obtaining those damages. And in the United States litigation system, where we have, or at least until recently we had, notice pleading, very lenient standards of proof for proof of damages, extensive pretrial discovery, terrific class action procedures. Well, terrific if you're a plaintiff's antitrust lawyer. Those are the guys who don't fly commercial. They've got their own Gulfstreams. And so antitrust is becoming more and more every day a very seriously enforced system of control of competitive business conduct worldwide. And so I wanted to set the stage for this discussion by setting that out as vividly as I could, and immediately turning to my longtime colleague and friend, Stu Chemtab, who, as described by Mark, has really had an extraordinary career, one of the real experts on international antitrust, very successful as a lawyer in the foreign commerce section of the Department of Justice, traveled all over the world looking at how the system is really put together, and now out in private practice actually seeing what it's like to deal with this from the client side. So Stu, how does a business cope with all of these multi-centric centers of antitrust terror?
Hire lawyers, of course. So thanks very much, Tad. Thanks for everybody for coming this afternoon. I wanted to pick up on Tad's comments about the expansion and proliferation of antitrust laws worldwide. I did a count of the ICN website the other day, and I counted 136 jurisdictions who are now members of ICN. And it started for 16 founding members back in 2001, so that gives you some indication. And so from the perspective of promotion of market mechanisms through the competition law enforcement, that's been a real triumph. Current and former socialist and communist countries, small city-states like Singapore and Hong Kong, very poor countries throughout the world have all seen the benefits of adopting antitrust laws. So from that lens, great success. But it's not been a complete blessing, to put it mildly. Sound application of competition laws requires, first of all, that there be clear objectives of the competition law that focuses on preserving and fostering competition, and with the goal of enhancing consumer welfare and economic efficiency rather than protecting individual competitors. Secondly, you need to have enforcement agencies with well-trained staffs that understand industrial organization economics and can apply that understanding to their investigations and decision-making. The agencies need to have sufficient resources to do the grueling tasks of investigation and analysis. There needs to be investigative and decision-making procedures that ensure that all evidence is reviewed and considered before decisions are made. And you also need to have support within the government and within the citizenry for the mission of competition agencies. To protect the competitive process, again, rather than individual companies. So we've now come to recognize that competition laws, if enforced or implemented unsoundly, can actually harm market competition and economic efficiency, globally as well as in individual countries. And we've seen real instances where competition laws have been adopted and used in a discriminatory manner against foreign companies or as an instrument of industrial policy, not to preserve competition, but to further domestic protectionist or industrial policy goals. And for those reasons, when I was in the Antitrust Division, that our policy was not to push countries to adopt antitrust laws who didn't want them. Because of all these prerequisites to make it work well, we saw it didn't make a lot of sense. And therefore, our policy was to wait until countries had decided on their own that competition law made sense for them, and then to help them draft it and implement it in a sound manner. Now, talking about ICN, they've been doing a very admirable job of promoting convergence of antitrust process and substance to a certain extent. So we've seen great progress in convergence regarding merger reviews, for example, merger procedures. And we've also seen remarkable consensus in the area of hardcore cartels, which I think couldn't have been imagined 20 years ago. However, in other substantive antitrust areas, particularly in the area of unilateral conduct, progress on convergence is much slower. And the difficulties in achieving convergence on unilateral conduct stems a lot from the differences in objectives of each jurisdiction's competition laws. Whether or not dominance itself is an evil, whether pricing by dominant companies should be regulated, whether antitrust should be used to compel access to essential facilities, including compulsory licensing of intellectual property, and whether the primary, even the important competition law goals should be the protection of small business or the promotion of fairness in the market rather than competitive process. Another common refrain is that competition laws should be used to level the playing field for local businesses against leading global companies by preventing them from taking advantage of their innovations, their economies of scale, their efficient distribution, their brand recognition when competing against local competition. And we see this theme expressing itself in merger reviews as well as in conduct investigations in countries around the world. A current manifestation of this problem may be the recent focus in a number of jurisdictions on so-called fourth industrial revolution issues, where American companies are often in the lead. And for example, just recently, the KFTC chairman, Kim Sang-jo, called for a global consultative body of antitrust agencies and international organizations to take joint action to address unfair competition in digital industries. The divergence of substantive antitrust analysis creates major challenges for companies operating on a global basis, where the innovations and efficiencies that led to their becoming one of the leading competitors in their domestic industries as well as in the world often are then challenged as abuses of the dominant position by other jurisdictions. In China, for example, one of the stated goals of the National People's Congress in adopting the anti-monopoly law was to pull Chinese companies out of the yoke of foreign IP holders. And this legislative objective was quickly seized on by the enforcement agencies, and we saw that in several cases, merger cases by MOFCOM, focusing on technology and IP, and also then in one of the early initiatives of NDRC was to go after foreign IP holders for abuse of dominance. And then just recently, the KFTC announced that they were revising their merger guidelines to give much higher priority, increased scrutiny to innovation issues, particularly by foreign companies. I think this is a real problem. And so for antitrust compliance by global companies is a very difficult challenge. Do such companies adjust their efficient business models to meet the rules and laws of all jurisdictions? In other words, adopting a lowest common denominator approach, which is really, moving to the most restrictive antitrust regime dictating world trade flows, or do they reduce the efficiency of their business models by having separate practices and models in each country to tailor them to the individual jurisdiction? And then this problem is compounded by what we've seen increasing resort to extraterritorial enforcement and extraterritorial remedies by an increasing number of foreign agencies. Now, on the one hand, of course, this may be reasonable for those jurisdictions to seek to protect themselves and their consumers from anti-competitive practices outside their borders that harm the domestic markets. And they would, of course, argue that they're simply following the lead of the United States, who was at the forefront of extraterritorial antitrust enforcement for many years. On the other hand, increasing extraterritorial enforcement and remedies has led to potential conflicts between enforcement regimes and remedies, uncertainty for business, and again, the potential for the most restrictive regimes to dictate world trade. So with that, I'll turn back to Tad.
All right, well, Stu, it's a pretty bleak picture with so many agencies claiming jurisdiction over any kind of conduct wherever located that has a domestic effect, that the extraterritoriality problem. You've referred to the problems of different substantive standards, different procedural standards, many of which are nowhere near as protective of the rights of defense in the U.S., as well as this problem of the incorporation overtly or covertly of what we would call more of a localist or protectionist type of consideration. And so before I advance the discussion to the next topic, I guess I would like to invite any of our other panelists who want to extend by making it seem even more dire than I've tried to, or perhaps to qualify. And so feel free.
Thanks. I'm more on the qualification side, I think. Having spent 20 years in the European Commission, having a certain point of view, I think it's probably not a coincidence that the organisers handed out popcorn before this panel started. I guess I'm here to be a bit more contrarian. Yes, there are problems of multiple jurisdictions. I did a merger last year with notifications in the EU and the US, and 25 jurisdictions around the world, 20 of whom said thank you very much after the enormous filings, put it in the drawer and went away again. The amount of cost to business, the amount of effort of the multiplicity of jurisdictions is clearly an issue, but not an easy one to solve. And it's interesting, I wasn't aware that the DOJ used to have a policy of not encouraging jurisdictions. I think that was probably a good idea because I think we have competition authorities around the world in jurisdictions that are not taking competition enforcement seriously in any particular way, but are there because it's now seen as something that every modern economy should have. So it's peer pressure that's led to that. I'd caution, though, on the point about substantive differences being inherently wrong for two reasons. One, the substantive law is inevitably influenced by the system in which that law is set. And US law has some characteristics that Tad was enumerating earlier, like class actions, like treble damages, like jury trials, like politically appointed judiciary, that are not present in all other jurisdictions around the world. In fact, are present in very few, if any. And, Bill Kovacic has written, I think over 10 years ago, that it's quite clear that concern of over-enforcement in the context of the US system has guided the development of US substantive policy. And if you read Trinco, you read Linkline, you read Credit Suisse, you read Twombly, clearly the Supreme Court is concerned about over-enforcement in the US. That's much less of a concern in the EU, where you don't have treble damages. You don't have, in any meaningful way, class actions, although they're on their way. Where you have, instead of jury trials, you have often specialist tribunals, such as the UK's Competition Appeals Tribunal, which is staffed by competition law specialists, not lay people. And so I think we shouldn't immediately judge the fact a system has different substantive rules to the US as saying that's inherently a problem. Some degree of divergence is going to be inevitable, no matter how much we advocate for convergence, when you have different enforcement systems.
All right, well, did you, Simon or
Yes.
Chris, did you want to?
You first, Simon. Okay, thank you. I mean, I listened to Stu and I keep asking myself, why? What has changed, right? From the glory days of 20 years ago when we all used to go to all these wonderful meetings and, as you say, the winds of history were behind our backs. I think what we see profoundly, especially since the crisis, is a lot of governments simply are not prepared to let markets alone determine industry and growth outcomes. And we can put efficiency and consumer welfare on a pedestal, and I'm a card-carrying economist. I was trained in the Anglo-Saxon world. I even served on the UK Competition Commission, so I've been in the trenches. I buy it, but I recognize that I'm part of a smaller number of people. We, in some sense, in many jurisdictions, we've lost this argument. And I think that's the first order issue, is actually winning that argument there. I think the second contextual point I would make is we see levels of cross-border foreign direct investment well below pre-crisis levels. The OECD is reporting returns on foreign direct investment, which must be below the weighted average cost of capital in many companies. So you imagine CFOs are raising red flags to overseas projects. So I think, and we also see lots more evidence of retrenchment and localization by firms. And so I think the firms are adjusting. Quite frankly, I think many of the big ones are adjusting much faster than we might recognize. And I think then I wonder if this this worry, which seems to be at the core of the US antitrust bar about procedural due process and all the rest of it, is the right battle to be fighting. I mean, I think you ought to put it differently. You might win that battle and lose the war, to be even more provocative.
Well, we're going to come back to that. And Chris, I want to just introduce the next subject.
Sure.
And since you were going to be my introducer.
Sure.
Uh-oh, Stu is going to intervene here.
So
Quickly, please.
I wanted to paint the picture a little more dire already, prompted by something Kevin said, which is private litigation. We talk about competition agencies and the challenges they face and the need for education. But then when you have countries, I think China is maybe a recent example, where they've allowed for private litigation, and you have a judiciary that has no background in economics, no concept of competition law, no concept of markets, and they are now adjudicating antitrust cases. This makes the challenges for companies operating globally so much even more difficult.
All right, let me, as I say, let me introduce the next subject, and Chris, you can get back at all
Sure.
this as when you get the mic. But This possibility of widespread international antitrust conflict was actually foreseen a long time ago. In the 1970s, there was a massive case by the United States Department of Justice and private litigants against an alleged international uranium cartel in which the main alleged movers were Canadian, Australian, French, that kind of firms that resided in countries that were friendly to the United States and more or less within their legal traditions. However, these cases and the broad American discovery and the reach of the grand jury subpoenas and all that rendered these allies furious, and they enacted blocking statutes and clawback statutes. I won't get into it, but they're forms of unhappiness asserted against American antitrust. So as a result, for example, in the OECD, a competition committee was formed, and for the last 40 or 50 years, within the OECD, the possibility for conflict has been considered, and the OECD, although it's not, their recommendations are not mandatory, they have some moral influence, but the OECD has been hard at work trying to harmonize procedures and substantive standards and so forth. Stu knows all about this. And more recently, we have the International Competition Network, which has been joined by almost every competition agency in the world, China being the big exception. And they've also been working hard to come up with best practices and recommended practices and trying to teach young antitrust agencies how to overcome the difficulties that Stu has itemized. And so I want to turn it over to Chris because he has studied very intensively all of these sorts of differences among the antitrust regimes of the world. And I think you ought to have a lot to say, Chris, about how successful this long-running attempt to smooth over and resolve conflicts in international antitrust, how is that going?
Well, I'll preface my remarks two ways. I should confess, I actually go by Christopher because my wife is named Chris, so I'm trying to make the lateral move. But setting that aside, before I get into the procedural aspects, I actually want to do my contribution to making the substantive convergence problem even more dire, which is beyond these issues of doctrine, what we see is emerging is a global assault on consumer welfare as the consensus standard of the goal for antitrust. And I had the privilege of testifying at the FTC international hearings this morning, and so I'm going to steal from Philip Marsden, who recently stepped down from CMA. And he said that the people who are trying to promote the adherence to the consumer welfare standards are like the Remainers in Britain. And the people who are advocating departure are like the Leave campaign. And the Leave campaign is not interested, they're anti-elite, they're anti-intellectual, they're interested in, it's political. And my concern is our attempt to address the debate over consumer welfare in technocratic economic terms may prove no more successful in convincing the leavers in consumer welfare than it does the leavers in Brexit. That there is a broader level of engagement that has to happen that is putting the premises of the consumer welfare standard at issue. And that if it's simply taken in a reactive mode and not proactively explaining what the goals and the benefits are of consumer welfare, much like the benefits of globalism are not made, we may well see a similar outcome. And I think that that's quite concerning. Moving from substance to process, it's actually really interesting. We talk about process first often in the harmonization projects because it's supposed to be easier. It is easy, probably easier. But there are some profound differences in terms of style. One of the reasons that the Europeans were so incensed by the investigation, the uranium investigation Tad refers to, is they don't do criminal antitrust. They also have an inquisitorial system that is inherently where the judge asks all the questions and is the seeker of the truth, and the parties have limited ability to interrogate. And so the forms that many of us from a common law tradition take for granted often do not translate well to other contexts. Stu mentioned something about education. One of the points I made this morning, Education, lawyers are trained typically as undergraduates in every other country in the world, except for now Japan and Korea, who consciously try to model what we do. That means lawyers usually have never taken a class in economics, probably had never been exposed to technical concepts, statistics. It's just not in their training. Then, immediately upon being anointed lawyers, enter the judiciary and the civil service ladder, where the primary criterion for advancement is not being overruled and sticking with the existing precedents. So you see a system that's actually socially constructed to be very, very resistant to the kinds of reforms that we're talking about. That said, I don't want to paint an entirely bleak picture. There's been some progress. I mean, to focus on the EU, for example, I look at the UPS case, where we start to insist, the ECJ insists on disclosure of economic evidence to the parties to allow them to interrogate. We see the Intel case, in which they said it was error for DG Comp not to catalog the meetings with competitors. Now, it was harmless error in that case. But my friends at DG Comp tell me that they have actually changed their practices entirely because they know they might not be so lucky, it's still error next time. So they're actually seeing this progress. So I don't mean to make a completely bleak picture. On the other hand, do we see the kind of disclosure, the kind of ability to interrogate the evidence, the kind of reasoned decision-making in all these instruments and all the enforcement agencies across the world? The answer is simply no. In fact, in China, a decision often looks more like a press release, and when you ask for the reasoning, they will simply tell you it's in the file without actually articulating any of the reasons. So then the question is what to do in this space, and the way that the question was teed up for me is about the OECD and the ICN efforts. And what's really interesting to me is the OECD and the ICN are revving up in this space. So the OECD, under the leadership of Makin Delrahim, has revived what they call Working Group 3 and have had their first meeting in November and will have the next meeting in December to start studying due process issues. The ICN is in the process of taking its agency effectiveness working group work product and moving it to the highest level formality, which they call best practices. And what you see is the Justice Department is pushing the multilateral framework on procedures, otherwise known as the MFP. And in fact, what was disclosed this morning at the hearing, the MFP is actually going to be adopted in some form by the ICN in a separate document apart from the Agency Effectiveness Working Group. Now, the standard criticism of this is that it doesn't do very much. And I think that people misunderstand the role that multilateral agreements play in these processes. So what I would say is until these things are instantiated into domestic law, it doesn't matter. These are aspirational. Second, what I've discovered is these multilateral organizations are constitutionally incapable of naming and shaming. And that is not in their DNA. I mean, they just can't. The OECD, you see these reports where they just say, this country does this country does this country does this. They cannot pick winners and losers. And so what I would say, that's where study groups like mine come in, which is we've taken the process of the entire investigative process, developed a series of 6 norms that they're designed to effectuate, avoiding conflicts of interest, promoting economic growth, promoting legitimacy in the government, control of a bureaucratic apparatus, and control of special interest groups. We've then broken down the investigatory steps into 30 different individual steps of the entire investigatory process and compared it across all 3 jurisdictions and come out with a series of recommendations. I think that kind of, we are actually in a position to make some claims as academics that the international organizations cannot. That's all still well and good, but someone said academics get to overrule the Supreme Court every day. The downside is nobody cares. So the question is, how do people care? What I'm discovering is that there are moments where you can change it, you can put it into real law. So one of the things that's happening, one of the, in my opinion, flaws around the world is that the same staff who prosecute and investigate also adjudicate. And I think that violates the basic fundamental norm of fairness of conflict of interest of being a judge in your own cause. There's actually a very interesting decision done by the European Court of Human Rights outside of the traditional ECJ, European court system, that says that having that happen violates the human right to a fair trial. And the only remedy to this is plenary judicial review. And then you look at the judicial review standards in Europe of competition law cases where it's manifest error of complex economic reasoning because the courts don't feel up to it. And what struck me is they're about where we were maybe 30, 40 years ago. And through a lot of judicial education, we now have a court system that can handle complex economic reasoning. This is an opportunity, I think. There's other 2 opportunities. The Chinese agencies are consolidating right now from 3 agencies into 1, which means they have to rewrite their procedural code. By definition, they're looking for best practices, and it's an opportunity. What's fascinating is they also, last year or 2 years ago, reformed their administrative litigation law, which is making judicial review of normative documents possible for the first time. And at the same time, the Securities Commission of China instituted something that looks like a separation of prosecution and adjudication. So what I see here is a vector where you can actually reach into other things to make it not a matter of antitrust enforcement, but a matter of good government. And understanding the ICN, the OECD, these are not final steps, but they actually may be necessary prerequisites to having the domestic law enacted in the way that you like. What you see right now is there are other opportunities. JFTC is going through a bit of a crisis right now because of a problematic intervention in a merger case. Korea is in the process of rethinking some of its antitrust enforcement actions. And when you find moments like that, that's when you change domestic law. And those are the moments, in my opinion, where you can actually really make a difference in terms of how procedural law is actually applied.
Great. Now, in the spirit of hurrying along, Kevin, I sense that you were going to have a comment in response to Professor Yu's characterization of the effectiveness or lack thereof of these international voluntary standards. But let me, I want to introduce the next subject and then give the floor to you. So I will ask if either Stu or Simon wants to say anything in light of Professor Yu's intervention. No, you're happy?
I'll hold off.
Oh, excellent. So, all right, moving right along. Next subject, we talked about procedural convergence. Now let's talk about the other type of convergence around objectives. We have a wonderful situation here in the United States under the current Supreme Court doctrine and the agency policy up to now, since it's been in effect since the 1970s. We care about the economic test, making sure that our antitrust laws make economic sense. That's the watchword. And we hear about all these other things creeping in, protectionist access to intellectual property on terms below market rate to benefit local competitors, or imposing extraterritorial remedies to grab a piece of some industry as a part of a merger review. And we have mechanisms that in theory should help to constrain these non-economic or extra competition policies that get injected into antitrust law, but there is no real overarching system. This is where I turn over to Kevin to talk about what do you think are the safeguards for this kind of pressure? For example, you had a very clear recent example in the Siemens-Alstom case where there were pressures to incorporate non-competition considerations, which failed in that particular instance. Bravo. How are things working on that?
Well, I think the Siemens-Alstom case is good for the competition community, good for the European Commission, and good for advocacy worldwide. For those of you who may not be aware of it, this was a highly political merger between a French champion and a German champion that Commissioner Vestager blocked a few weeks ago. She came under enormous public political pressure from the two national governments. There was a lot of pressure within the European Commission, but there were remedies discussions, but the parties were unwilling to give up the remedies that the Commission had identified. So it is, I think, a good example of the Commission withstanding political pressure. And just to speak about Vestager for a moment, her term as Competition Commissioner runs out this summer. She is looking for another job at EU level. It would have been very easy for her to curry favor with France and Germany in order to get a better job, but she chose not to, which I think says a lot about her. I would also say that if you do want to politically influence a merger decision, then to quote Sir Humphrey Appleby in Yes, Prime Minister, if you want to do that damn stupid thing, don't do it in that damn stupid way. Making it public, making it loud is a very bad way to have political influence. France and Germany would have been better could have been better advised, I think. Not that I'm advocating political interference in merger decisions, but as a result of this, Germany and France have come out with some proposals now. two of which are quite worrying, one of which is to give the European Council a last word on merger prohibitions. You have something similar in various laws around the world. They have it in the UK, they have it in Germany, where prohibitions can be overturned by the relevant minister if they're deemed to be in the national interest. They're very, very rarely used. They were last used in the UK for the merger of Lloyds and HBOS during the financial crisis, where the competition authority wanted to prohibit the merger, but they were overruled by the government on grounds of financial stability. In the medium term, that proved to be a serious competition problem. So that probably wouldn't be done again anytime soon. But now France and Germany are proposing that at EU level. They're also proposing that there should be a kind of default presumption that markets are global, which obviously is not an exactly fact or evidence-led conclusion in all circumstances. It's not clear where that's going to go. I tend to think that the European champions debate in Europe will recur every few years and then will die down, simply because for every France and Germany that want one of their companies to be a European champion, there are 26, perhaps soon to be 25 member states who are going to be customers of that champion and may rather object to it. And yes, sorry, thank you, Christopher. I did hope that I'd get through today without discussing Brexit. But thanks for bringing it in. I'll pay you back for that later.
I'm here to serve, Kevin.
It was reassuring though, because if the Lexiteers are the non-consumer welfare advocates, then ill-informed, badly thought through, and will ultimately lose, I think, is probably a good objective. What else to say? Checks and balances. I think first, I think the work that Christopher's done over the last year or so is excellent in terms of identifying restraints and naming and shaming, as he said. He's quite right that multilateral institutions will not name and shame. The European Commission will not name and shame national competition authorities, even though it could easily has the power to do so. It prefers to conduct the diplomacy behind closed doors rather than out in public. So the work of people like Christopher in putting this kind of information out there is extremely useful. I think we do have some progress, just to pick up on that. I mean, 10 years ago, there was an East European National Competition Authority that sent a prohibition decision to the client of a friend of mine after not having gone through a statement of objections, passing on of evidence, a hearing. That was immediately overruled on appeal, and the National Competition Authority have since improved their practices, fortunately. So it is a long, slow process. I'm dealing with a case in another more long-standing member state at the moment, where this goes more to the UPS point that Chris raised. In the statement of objections, they said, we don't have to do an as-efficient competitor test for these rebates, and it's impossible to do on the basis of the evidence. Then in the decision they said, okay, we have done an as-efficient competitor test, but we're not showing you the evidence. And then on appeal said, yes, okay, we got that arithmetically wrong, but we've done it again now, and it's still an infringement. So there's still work to be done, clearly, even within Europe on rights of defence and things. But moving from these minor levels of detail, there is also a discussion going on in the UK at the moment about the level of review, another point that Chris mentioned. The UK Competition Appeal Tribunal has a full review of all the facts and evidence. However, its chairman has written to the UK government suggesting a move to a more judicial review type standard, and also limiting parties' ability to introduce new evidence or arguments at the appeal stage that they didn't introduce at the administrative stage. And the reason for that is that the CMA feels that it is under-enforcing in the UK at the moment because it's finding it very difficult to survive on appeal. So whatever the merits of that, I think the direction of travel, at least in the UK, is towards the judicial review standard. I'm slightly sceptical of the point that is frequently made, and it is there in the court's case law that Christopher made, that the European courts focus on manifest errors of economic assessment and give the Commission significant margin. First, because that isn't relevant in cartel cases. In cartel cases, all of the facts and evidence are relevant to the fine. So in effect, everything is reviewed by the courts. And I think we've seen a trend over the last 10 or 15 years of, although the courts haven't formally changed how they describe their standard of review. They are looking at a little more detail. And I think this is because of peer pressure, of discussions such as this, as to, what the minimum level of review should be. And I think those are going to continue over time. I mean, generally on all of this, I'm a kind of glass half full kind of person, that we do see progress in the right direction. I don't think the consumer welfare standard is under as much threat as Simon seems to, but we can maybe talk about that. Sorry, Christopher, I beg your pardon. As much threat as he thinks, but we can talk about that later. Through peer pressure in the OECD, through peer pressure in the ICN, through our universities, I think we are educating a generation of competition lawyers who go abroad to study, who don't study US competition law or EU competition law, they study competition law. They are assimilating best practices, which they then take home to their home authorities. They become practitioners, they become enforcers. So I think we will see progress over time, but it might be a little slow.
Thank you, Kevin. Professor Yu, would you care to respond to that, or?
No, I think that I actually don't mean to say that it's not making progress. I'm actually also not just speaking about the EU. I'm talking about on a global basis. I would say that practices in the EU are more promising than they are in many other countries, and I think that Kevin makes a point. It's a long play, and you can't be in this in the short haul. It's going to be a very long trek. But someone once told me. My son was doing a project on planting trees. He said the best time to plant a tree was 30 years ago. The second best time is today.
Questions for Kevin before we proceed to the next subtopic? All right. So a new form of trying to cope with these issues in international antitrust has emerged in recent years, and that is the trade treaty. There were some elementary provisions of the NAFTA that dealt with competition law, but they were not really too strict, and they were not enforceable under the agreement in any event. We have had two previous unsuccessful efforts to create a multinational competition code, one being the Havana Charter, which would have created an international trade organization, which failed. One, an effort to put a competition discipline within the WTO, which was made one of the ministerial issues in Singapore in 1996, which ended up not to be going anywhere. But there are still calls these days for a different attempt at multilateral competition codes. The U.S. has a number of bilateral treaties, U.S.-Chile, U.S.-Peru, Chorus 1 and Chorus 2, meaning Korean-U.S. Competition provisions were being negotiated in the two main treaties that got derailed at the beginning of the Trump administration. That's the TTP and the TTI, I can't remember. TTIP, yeah, which was an equivalent thing with that would have been with Europe. And the USMCA, actually, still pending approval, has some quite nice procedural provisions. So I want to toss the ball to Simon, who is an expert on this business of using international trade agreements to impose competition disciplines, and see if he can enlighten us as to whether this is likely to be a widely used and successful format for resolving antitrust conflicts.
So, thank you. I'm going to talk mainly about the free trade agreements, which include competition provisions, except that of the European Union, which I think is its own special and elaborate system, which is probably very well understood by most people in this room. So let's talk about the other FTAs. Of the other FTAs, we now have a very large number, I think north of 100, which have competition chapters, their own competition chapters in them. This is not the only area you will find competition language in an FTA. You might find some of it in the preamble, where often competition objectives actually trump trade objectives in some cases. And also you'll find other chapters of free trade agreements which contain competition provisions. I'll say a bit more about them later. If you step back from all of the sort of legal text and the like, you see, I think, three ways in which trade agreements have been used to try and shape the antitrust procedures of another country. It seems to me to be three vehicles. And I'm not saying that each agreement pursues all three, and it's very clear that the US and the EU over time have pursued different mixes across these three. But the three seem to be the first item you can try and get the other party to substantially upgrade or improve the statement of their law. That's really where you can see quite a lot of action. And for countries which had very nascent laws or didn't have laws at all, this was actually could potentially be very helpful. The second area you could see action in was in supporting, possibly in conjunction with the trade agreement, the development of what you might call better habits. So training agency staff, bringing them over to Brussels or to Washington alike. And as part of the FDA's rollout and support, often done by an agency to agency, you could build up the other party's agency, and assuming that those people stuck around, they had the right incentives to stick around, then at least you had better and more reliable counterparts who understood at least the better principles of enforcement. So that's the second area. The third area is in sort of after the agreement is done, what rights do you have to encourage the other parties to follow the basic principles of non-discrimination, due process, and all the rest of it. Here on this third part, this is the weakest part, and that is because many competition officials and the competition bar did not want to introduce formal dispute settlement into this area. So we ended up having many more consultation mechanisms, where at the end of which is unclear to me what that's supposed to accomplish, other than to provide for an exchange of views. And we recently had this case call for consultations under chorus, which the USTR has put forward, which is an example of this. So we have essentially three vehicles for influence: getting the law changed, developing good habits through training people, and then rather weak, what you might call, we don't want to call them enforcement, they're not really strong enough to be called enforcement, but some type of mechanism for sort of talking about problematic cases. And that's about as far as it has gone in these trade treaties. And I think a lot of it's been held back because, of course, there is the long-standing suspicion amongst the antitrust bar and community of the trade policy community. Let's be open about this, right? I have sat on both sides of this fence and seen the food fights which take place from time to time. And so this is a vehicle which I don't think has been used as much as it could have been. Now, if you are worried about certain sort of issues of either procedure or organization and how agencies should operate, there are other chapters in trade agreements which have interesting precedents. So in the government procurement chapters of many free trade agreements, there are explicit rights given to firms which lose bids to be able to ask for a domestic review, an independent review as well. And so that is not alien and not something which is inconsistent in a trade agreement. Second, a weaker example, in the area of customs valuation. Inside customs houses, firms which feel aggrieved are under some trade agreements given rights, which rights to have the customs officer's valuation of imported goods checked. So this can be done. Again, those vary enormously in terms of how strong they are, but it does suggest that there is something. The broader theme is what checks can we have on the arbitrary use of state power? This falls under that category, definitely. And then the third area, which I think is the most interesting, especially since we're talking in Washington, and something which has always intrigued me, is the incredible sparseness of the US competition law, of antitrust law chapters in free trade agreements, 6 pages in the case of the original chorus. And then you contrast that with the extremely detailed, fine-grained intellectual property rights chapters of free trade agreements, which go chapter and verse into obligations, enforcement record rights, penalties, matters of due process and the like. And I've always been a bit baffled as to why the same country pursues such an aggressive, hardline, elaborate view on IP but not on competition. And if the antitrust community were to wake up and decide they want to get serious, they only have to look at their own country's IP chapters in their free trade agreements to get a few good ideas about how to beef up. So I've described to you the three mechanisms which have been are used generally. They are, on the whole, quite weak mechanisms used in FTAs. But that, the history here doesn't have to be the future. And in fact, ironically, there are some excellent precedents in United States free trade agreements on how to take this forward.
Well, thank you so much, Simon. Before I open up, I just have to tell you how incredibly thrilled I am to hear your last remark, because my wife actually negotiated a number of those IP provisions in U.S. trade agreements, and every time she hears me whining about weak international antitrust discipline, she says, "Why don't you do what we did back in the Reagan years?" So anyway, got a friend there. All right, fire away. Stu, do you have a...
Yeah, I have several comments. I guess I'm surprised that Simon didn't pick up on his provocative first comment about, totally misguided to be focusing on due process. And I wanted to explain that a little bit and then move the discussion a little bit towards substance and not just trade treaties, but trade policy in this area. So first of all, why process? Why focusing on due process? I think, one, because it doesn't require you to get into the substance of any particular investigations. You can look at it at a higher level, and it's also measurable. Do they have an agency? Do they have an independent judiciary? Is there a right for cross-examination of witnesses? And so there's a measurable things that you can put into an agreement and see whether or not there's some compliance. And people may have seen recently USTR just call for consultations with Korea over their failure to abide by some of the requirements in chorus on process. And when I was in the Justice Department, we were okay with some fighting to have agreements that focused on process. But substance was really a problem. And what was the reason? Because we were afraid that you would go to a lowest common denominator approach, particularly if you have dispute settlement and challenging an enforcement agency's decision on a particular matter. And so there was a lot of fear about that, and also thinking that that the U.S. system was was different than other systems. We didn't want to be forced into a global approach that might be a lowest approach. But there are examples. You didn't mention the Singapore U.S. agreement, and also state enterprise provisions, chapters of FTAs. So the Singapore agreement, which I have to negotiate, actually included substantive obligations, antitrust obligations on Singapore GLCs, government-linked corporations. There was a lot of consternation at Justice Department within the government about whether we wanted to go that route, partly because those provisions were subject to dispute settlement. And it was at a time that Singapore didn't yet have an antitrust law. But there's an example of that. And we have several examples in U.S. trade policy where USTR has challenged failures to enforce competition law as a violation of WTO, as a non-violation violation, it was called. First example that I'm aware of is a soda ash cartel in Japan, where the four companies controlled access to terminals, and therefore U.S. companies couldn't sell their soda ash into Japan other than through the cartel. And then there was the famous Fuji-Kodak dispute, which I think was probably misguided, but really focused on the failure of the JFTC to go after distribution restraints imposed by Fuji. So you do have some examples, and you have the Section 301 itself, which provides the toleration of cartels could be a violation of 301 subject to trade retaliation. So, 2 more minutes.
No, please. You're doing great.
The question is, do we rely on these long-term solutions, slow convergence, dealing with due process, and they're necessary, but they're not sufficient for dealing with problems. And do we need to reevaluate whether or not they're, in addition to the carrots offered by competition agencies in discussing logically and rationally with their counterpart agencies what best practices and why it's good for your country, also to have some sticks to deal with particular problems that the antitrust agencies are not equipped to handle. They can't cajole. And that's the job of the bad cops. And so I throw out there whether or not there needs to be some rethinking about the need for some bad cops, the need for bringing in trade policy and trade negotiations to resolve some problems, particularly where competition laws are being, at least in the U.S. view, would be misused for non-competition reasons. I'll stop there.
Response, other questions for Simon?
Can I just say on the
Please.
sticks, on the carrots on the sticks? If there has been a lesson from the last 10 years more generally, not just in the competition area, but at the WTO, we have seen a huge number of trade distortions introduced globally. At least that's what my team has documented. And we've seen an extraordinarily small number of trade disputes brought, even before the problems of the appellate body reappointments of judges came up. And that strongly suggests to me that we have a glass house syndrome going on. And as we say in English, people who live in glass houses do not throw stones. And I fear that you might create the same dynamic actually in the competition area, which is that once an agency has behaved badly and another agency has behaved badly, they'll never criticize each other or bring cases against each other. You have to be very careful about constructing a system where ultimately the major players, if the only way a case gets brought is a government brings a case against a government or an agency brings a case against an agency, then that system can fall apart once many agencies have broken the rules.
So that is an argument for a kind of independent agency,
Yeah.
is that?
Somewhat, that was the European solution, ultimately, right? To have the Commission who can bring cases. But if you are looking for solutions, one has to go that route. If you're serious about sticks, you can't trust either the agencies or the governments to enforce alone.
I have a question, if that's okay with my other panelists. Simon, is there a possibility for creating an agency that is not really a trade agency, but is nevertheless an international dispute resolution agency? In other words, we do have mechanisms. The former director of the Canadian Bureau of Competition, John Peckman, gave a very interesting talk this morning that I listened to, in which he cited some other fields of law. For example, he referred to the criminal MLAT that exists that permits the United States and Canada to cooperate in criminal antitrust matters. And he said, well, maybe there should be some kind of a civil MLAT. And he also referred to an organization I'd never heard of before. I think he called it IESCO, which is sort of an international cooperation forum for the enforcement of securities law. Are there models for enforceable international obligations outside the trade bureaucracy? Because I think I agree with you. There's a kind of a oil and water, cats and dogs thing about competition and trade, Baltimore and St. Gallen.
I mean, we're getting well into the areas of more international law than I know. But I think your instincts are right. There has to be a way of figuring this out.
We are at the sunshine and light hors d'oeuvres phase of the day. So I love panels like this where somebody else does all the work, which is to invite incredibly well-qualified and articulate panelists, and I just kind of let them go. So thank you very much.